Robert Appleton is a partner in the law office of Day Pitney, LLP. Bob concentrates on white-collar matters, government investigations, and compliance in the areas of the FCPA, export control, and financial sanctions. Bob provides strategic counsel to those facing state, DOJ, or SEC investigations, advice and defense on FCPA matters, export control sanctions, and a wide range of compliance services, including compliance assessments, training, and preparation of tailored compliance programs. Richard Bistrong spent much of his career as an international sales executive, where he was vice president of international sales for a large publicly traded manufacturer of police and military equipment, which included residing and working in the UK. In 2007, as part of a cooperation agreement with the U.S. Department of Justice and subsequent immunity from prosecution in the UK, Richard assisted the United States, the UK, and other governments in their understanding of how FCPA, bribery, and other export violations occurred and operated in international sales. So with that, I'd like to turn the program over to our presenters. Bob, the floor is yours.
Thanks very much, Tom. And Tom, first I'd like to thank you, Vanessa, and LexisNexis for the incredible opportunity to present today, and of course also to my co-presenter, Richard, who we will discuss how Richard and I met in a few moments. So with that, I'll proceed. So third parties, what we're going to discuss today and focus on principally is how third parties pose perhaps the single greatest risk to any entity, individual, corporation engaged in commerce abroad. And we're going to discuss through identifying what we think are the most significant third-party risks and discuss how we measure them, how to address them, and hopefully how to mitigate and address those risks. So the first slide is a slide that presents, in my experience, the different categories and types of risks that present to a corporation that's engaged in commerce abroad. So I will go through, what I'll do is go through those five and discuss how they are presented and how they pose risks to companies and why. So first we have on the far left reputational risk. So what is a reputational risk? Well, that's a risk that involves some obvious red flags or relatively obvious red flags about the area in which a company might be engaged. For example, in a high-risk, low-integrity region, some of those risks might present themselves through simply the reputation of the region, the entity, the country, the party that you're dealing with, or the individual. So some of the things, for example, on third parties, where we're talking about either individuals, agents, subsidiaries, or intermediaries, are can be presented all related to all can emerge through this kind of a subject. For example, a reputational risk might be when the third party doesn't have a compliance code or cannot identify a prior instance where it has signed a compliance agreement. Perhaps they've been terminated by others before this, or the information provided by the third party is not verifiable. They have a problematic history with law enforcement, or don't have a track record at all. So that's a type of a reputational type risk about the third party that could be presented, which needs to be addressed. The second category is relationships. So things about the third party and the relationships that might emerge could be that they're related to a government official in some fashion. They either employ one, have a familiar relationship, they have either worked for or associated with a government agency, or have a principal that's actually an official with the government, or they have a
Hello?
meet with the government officials alone without the corporation. So that's an example of a problematic relationship.
Hey, Bob, you clicked out. The audio clicked out for just like half a minute.
Oh, did.
So you could just back up just slightly. Sorry about that.
Oh, okay. Sorry about that. It's just some of the risks in the relationships were the third parties. I was going over some of the things that about the third party and their relationship with the government that could pose a red flag that should be something that should be addressed. For example, when the third party urges that he or she meet with government officials alone without the corporation, or they request that they meet with a particular other agent or another intermediary without corporate representatives. Capabilities, things about the capabilities of the third party that might jump out at you that may pose a indicia of a red flag. For example, they have no track record with the product or service. They don't have an actual office or staff. They were only recently formed or incorporated, or they've actually represented many different industries in the past. Those are all types of things which I found to be later determined to be problematic. Then compensation. This is a significant risk. And I think both Richard and I have quite a bit of experience with this with respect to the nature of the relationship, the way in which the third party seeks to be compensated. Commissions, a typical term for the way in which third parties seek to be paid. Their commission, while there's often a standard percentage in a region, they might ask for a higher than normal commission. That's a red flag. Or they don't identify the actual responsibilities and duties that they're going to perform. They're, in fact, not expected, if they're not expected to perform specific tasks, or they actually ask for an advance payment. Another significant potential red flag is when they request invoices that are higher than the actual amounts owed or paid, which can often signal that their additional funds are being passed on for an improper purpose. A success fee or an actual percentage of the contract value are also red flags. And the last category I label unusual circumstances. These are just types of circumstances that can be presented concerning the third party or by the third party that can jump out and should be things that you may want to identify or dig further. For example, you ask them to sign an FCPA attestation, a compliance code, or a written document where they confirm that they're going to abide by FCPA or UK Bribery Act provisions, and they refuse to do it. They refuse to be audited. They refuse to identify like beneficial owners. They don't give examples of what they've done in the past or prior representation. They guarantee success. That's always a big red flag. Or they suggest commissions that are typically not acceptable in the local jurisdiction. So those are just five general categories, overviews of what third-party risks and the areas in which they might emerge. Of course, it's hard to be absolutely specific and identify each and every one that could trigger, because these things, I find, change frequently, and they may not be something that is a red flag as things move forward. Is there a hierarchy of risk? So is there risks that can be patterned or that can be mapped, and do they flow? Well, I think it's relatively clear that the parent liability at the top of the chain can assume many different types of risks and different types of liabilities. For example, successor liability, which is something we'll talk about in a little bit later, and it's highlighted by the Goodyear Tire case, which is when a company merges or acquires a subsidiary in a local jurisdiction, you may also inherit or acquire the issues and FCPA problems that subsidiary has been engaged with. Or subsidiary liability, which is a straight piercing the corporate veil, which is something the SEC has been very popular, much more willing and able to do, which is to be charging parents with the acts of subsidiaries. For example, what they did in Alcoa and also the Biorad case, which is holding parents responsible for the acts of the subs in the local regions. So both of those are areas where parent corps can assume the liability of either the merger and acquisition targets or the subs. And at the bottom, the lower level, some of the other areas that happen on the ground and in the local areas which can lead to liability for the parents, violations of the local customs and law, something that's often overlooked, sometimes where acts or activities of the agent might violate the local laws and the local customs and reach and trigger responsibility and liability for the parent. Travel and entertainment, a good example, which we'll talk about towards the end of the program, is the BHP Billiton case, where the company there was faulted and fined $25 million simply for compliance failures without a contract that was awarded as a result of the travel and entertainment that was provided. Now, travel and entertainment alone now can pose a risk for liability to the parent and what happens on the ground in cases. And one thing to always remember in the case of FCPA cases is that under the books and records provision of the statute, it's essentially strict liability. So for a books and record violation, the government doesn't need to establish knowledge to establish a violation for the books and records provision. And this is typically where travel and entertainment violations are often noted and come within. Fees and retainers, we've talked about that, compensation involving the agents and intermediaries as well as those on the ground. And gifts and hospitality, another big issue, another very prominent issue today, where can pose real risks for the parent companies. And one good example is the Timms case, a recent 2014 case by the SEC. It was an enforcement action against the company where they were organizing extensive travel and providing expensive watches to Saudi Ministry of Health officials in exchange for valuable contracts from an Oregon Ministry of Health, Oregon defense contractor. So in a typical case, gifts are not central to the enforcement action, but are a complement, not the sole basis for the charge. But here there was a quid pro quo, an actual contract. So gifts and hospitality, another high risk potential area. To give some real life examples and real life stories about how third-party risks emerge. And this is actually the story about how Richard and I intersect, and it starts in 2006, where I had just taken over as head of an international anti-corruption unit in the United Nations, and we had several cases, and we were looking at contracts throughout the world, and we were focusing on third parties, and one of the third parties we focused on is featured in this report. And that third party had an agreement with numerous companies. It was very vague, and it was a percentage commission to provide contracts for companies that were offered by the UN, and in fact were very successful at it, as they had some significant help from a UN insider who was a chief procurement official, who we ended up establishing was being paid by the third party to provide inside information. So in one particular case, this third party, who was representing a very large food supplier, had been successful in steering quite a number of very valuable contracts to this food supplier for food rations throughout the world and throughout the developing world, and it was significantly aided by this particular insider. And in one case, the inside official of the organization, had provided the third party with the bids of the competitors to the company that the third party represented. And so that company sent their top officials over to the Roosevelt Hotel in New York. They gathered, the procurement officials secreted the bids out of the organization's headquarters. They met in the hotel room. They looked at the other competitors' bids, and the company then altered their bids with their equipment, and then had the procurement official resubmit the bids, and lo and behold, and to no surprise, won the contract. So this is one of the contracts that this third party achieved for one particular company. So our focus began to be obviously quite intent on this third party, how they operated, who they represented, and the contracts they won, which transferred and pivoted over to a company that begins with an A that we were looking at, and we eventually saw that there was similar issues with respect to the contracts that were awarded to this particular company. So in January of 2007, as a result of that investigation, or in connection with it, I sent my co-presenter, who's with me today, a letter dated January 5th of 2007, and I guess I would ask you, Richard, at this point, if you remember receiving it.
I certainly did. That's a letter I wouldn't forget easily, Bob. And nice to work with you again. And I'd also like to echo my appreciation to Tom and Vanessa and the team at LexisNexis for the opportunity to participate in today's webinar. So, sorry, Bob.
Go ahead, Richard. I was just going to ask you, when you received the letter, can you tell our audience what happened?
Well, I was at that point in time, Bob, I was heading into what was my 10th year as an international sales vice president in a very successful, rapidly growing, publicly traded defense company. And I was spending, over the course of that decade, approximately 250 days a year overseas, pretty well distributed around the globe. A number of times I worked and resided out of the United Kingdom. So in the defense business, your touch points are basically the Ministry of Interior, where police products are traditionally purchased out of, and the Ministry of Defense for armed forces. Between me and them were the third parties, the intermediaries that we're talking about today. So I had very little commercial sales in my portfolio, so almost 100% of my sales activity was oriented around public procurements. So it was around early 2007, as that letter indicates. I was actually in the United Kingdom at the time, and my secretary or assistant put that letter on my desk. From the looks on her face, I think she read it along the way, and I just remember looking down at it, Bob, and reading, and just the PG version of my reaction is, who the heck is Bob Appleton? And as we know, that letter then triggered a number of different events, which I think have a lot of relevance to today as we look at international law enforcement cooperation, cooperation among private and public entities, in that your letter here ended up resulting in my being terminated from my former employer. And as I think you're going to share, you know, the results of your investigation were shared with this Justice Department, which then led to me being the target of a Department of Justice criminal investigation, and also an investigation in the United Kingdom with HMRC, which is Revenue and Customs, about similar activity that was occurring while I was residing out of the UK. So that short little letter that you sent me really had a number of different consequences and results among different investigatory entities.
Right. Just to highlight for the audience, the letter just simply stated I was conducting an investigation and asked you a number of questions and requested you produce a number of documents. And as Richard, as you indicated, at the time I was also, I had just recently left the DOJ and had many established contacts there. So I was sharing my results, investigation results with the department, who took many of the investigations that we conducted further and ended up really significantly supporting the DOJ fraud section and getting their FCPA investigations off the ground, and led to a number of them, of which this was one. So as you indicated, this set off a chain of events with respect to you and the company, as well as the third party, and involved also other international cooperation, other international officials furthering this particular case and others. So from there, let me move on to the next slide. So the question whether that was the only case, it was not. We had several cases in which third parties ended up successfully procuring very valuable contracts that steered to favored vendors, including a $100 million telecommunications contracts over a period of 8 years that a third party steered to an Indian company with the help of another insider. In that case, was identified through the fact that, and we'll talk about this theme as we go through this, the benefit to the third party and to the, the benefit to the insider from the third party was not direct. So the third party actually paid the insider through giving him an valued co-op in Manhattan, sold to him a $2 million co-op for well under $1 million in a LLC, the name of an LLC, and so there was no identifiable quote-unquote bribe that was paid, but rather it was a transaction that set up something for the insider that was a little more involved and not as easy and direct as a straight payment, and that ended up keeping the scheme under wraps for many years and wasn't identified until 8 years later when we looked very deeply at the transactions and knew that real estate was a high risk, or an area in which insiders were typically paid. So we ended up doing a land record search of the official and found these transactions.
Now, Bob, after the UN, you went on to the Global Fund. I mean, keeping sort of the focus on the third-party behaviors and conduct that you saw at the UN, was there any continuity or similarities to what you experienced then in the next phase of your career at the Global Fund?
That's a good question, Richard, and yeah, thanks for asking. I mean, absolutely. Well, one of the, in 2010, so I went to the fund in Switzerland, but essentially all my efforts were throughout Asia, Africa, and the Middle East, as well as Eastern Europe and some in Latin America. And I was really able to see firsthand how contracts, the process worked with the governments in almost 100 countries, and the way in which corruption and emerged. And the themes were very consistent. And this time, while some were different, the third party still played an integral role. In a lot of countries, the governments mandated who corporations used as their third parties, and required certain people to be involved in the contract process, or they only dealt with certain individuals or companies or things like that. And one of the things we found was that often government officials and family members of government officials and people they favored were involved in bidding processes, either through establishing companies as competitors or through some other means. And in this particular case, this slide, it was in Burkina Faso. The wife of the president actually was the vendor who won the contract, into whom the contract was steered, but you would have never known it through the name of the company. But they actually received a very large contract for 2 million nets, which they proceeded to distribute throughout the country, which ultimately were made by a Chinese company that had no medicinal content. So basically the country got anti-malaria nets without any medicine on them, which is also, as a side note, one of the questions when, well, who does corruption hurt? Well, this is certainly a case which shows who it does hurt. But anyway, to answer your question, Richard, we definitely saw patterns. In some countries, you couldn't get a contract without either paying a commission or a gratuity to the government official. And often when the activities reached deep into the governments were very reluctant and to police themselves, as you might imagine.
Sure.
And so what about you, Richard? When you, in your experience, and how did you first address or confront the issue of a problematic third party?
Well, thank you, Bob, for asking. If we look at the photograph up there with that sort of sweeping landscape looking very cold, it's from a location called Tierra del Fuego. So for those not familiar with where that is located, it's, I think, less than 600 miles from Antarctica. And it's the place where you might go if you're taking an excursion to Antarctica, where you'll get all your kit and all your equipment. So it's about as far from the home office as you can imagine. And it's very iconic of the real-world third-party risk that exists. Because it's from this location, very early on in my international sales career, where a third party that I had been dealing with successfully, without really seeing any indications of corruption, he shares with me that as part of his success and his success fee, that he is paying tolls to win tenders by intertwining corrupt and legitimate business services. Now, when he said to me that he was paying tolls, I didn't have to ask what he meant by that. And that very well reflects on the language of bribery and the conversations that occur with third parties, which are put in very colorful terms. And as I've shared before, Bob, this language of bribery involves many interesting words other than bribe. So in this conversation where he's sharing that he's intertwining corrupt and legitimate services, what's interesting is he's not asking me for anything. He's not asking me to change his commission, to change the deal. He's just sharing me that that's how he's winning, which I think reflects so much of the challenge of third-party risk, in that it's very difficult to detect because often it doesn't involve the exchange of delivered funds that we might think of. So Bob, it was during these initial conversations, and this would be repeated out over and over again, especially over the next few years, I nodded my way to being a co-conspirator to violating the FCPA. Because as you and your colleagues at the DOJ well know, understanding that a part of a commission is going to pay a public official, I'm now a co-conspirator. And that type of activity and behavior sort of opened up the gateway to where when the UN happened and I had to do more than nod my way through that transaction, I had already been indexing it to, well, I've been doing this anyway. So
Richard,
that's a little bit. Oh, I'm sorry, please.
No, Zach, I was going to ask you, what was the relationship? I mean, at the time, did you inform your company or your compliance department? Did you call the home office? What did you do?
Okay, that's a great question. So as a precursor to that, I knew that this was illegal, okay? My company presented me with FCPA documentation very early on in my, after I took this role as the International Sales VP. I was given plenty of time to read through the law and to ask questions if I had any. So I think I want to be clear that I knew my conduct was illegal even back at Tierra del Fuego. I didn't call my company, and I'm sure if I would have said to my company, you know, should I engage or not engage in illegal behavior, they would have shared with me not to engage. But I think the more interesting question, and this goes into some of the behavioral topics we've talked about before, is did I think they would want to know? And I think that's the more challenging question when it comes to third-party risk, is are your employees feeling that in these type of situations that management does want to know, regardless of bonus or compensation or sales quota? When these type of conversations occur, the default should be called compliance. But that's not how I felt.
And in your view, and you said, you know, this is back, I mean, we're back now in 2006, and compliance and the effort is just getting underway. But in your view, was the third-party risk issue something that your company was really aware of, or were they being made aware of it by the salespeople?
It's hard for me to really answer that, just not knowing what their perspective would be. But in terms of my own view, Bob, I mean, looking at that photograph there, I certainly irrationally calculated risk. There were no witnesses to that discussion. You can look at that landscape there, and I didn't think anybody was listening or observing me. So I just calculated that there was no chance of getting caught. And as you well know, in 2000, well, that picture's from 1998. It wasn't like there was a lot of discussion about FCPA enforcement at that time. So I wasn't really calculating the probability of getting caught and thinking about criminal deterrence either.
Right.
And as this slide demonstrates, and for most of our callers today, and much of your experience and your current practice, Bob, is there's a lot of activity going on at the top of that funnel, right? Compliance policies, compliance procedures, you know, the organizational relationship of the compliance and the audit and the investigatory teams. But at the bottom of that chart is where the risk is, right? I mean, I think foreign bribery laws are unique in that they occur the furthest distance from the home office. And for people out in the field who are engaging with the Tierra del Fuegos of the world, you know, they're being compensated to increase and grow the business. They're not attorneys, they're not auditors, they're not regulators. They're people that are being compensated to increase sales to some level or the other. So far away from home, often unsupervised, you know, the question is, how can this be detected and why is it occurring? So I think we'll drill down into some more of that, but the challenge I don't think should be understated in that this distance is represented in this slide makes this a very challenging law to take hold, you know, at the sharp end of business.
Well, just one question along those lines. I mean, in your view, is in the field, is the risk being understood, and is it being mitigated?
Well, you know, that's a great question. And I ask, you know, I guess I'm going to answer your question with another question is, you know, for today's participants, you know, is that compliance being calibrated to the real world risk that the business teams face? In other words, as you know from your own experience, Bob, risk in Asia is much different than corruption risk in the Middle East. So are your business teams being given a set of tools that's calibrated to that real world risk, and a set of tools that will be embraced as business growth and ethical behavior and anti-bribery compliance in my organization are complementary? I can deliver both to management because at the bottom of that funnel, the output actually makes sense for how I'm being compensated and directed to grow the business. So you're not putting compliance and sales growth as a zero-sum game.
Right, it's a great point. But one of the other things you raised worth just mentioning and expanding on for a minute is on the issue of risk and how it's not universal, how risk is, especially third-party risk and corruption risk, is different in every region, something I as well experience and I think is a very important point, and that is the way risks might emerge in Francophone West Africa are completely different than the way those risks emerge in Cambodia, Vietnam, Thailand, in that area of the world. And so when you're addressing risk, it really needs to be tailored to the geography you're operating in, and it can be a completely different equation as well, and also can involve completely different people to help you manage that risk, which we'll talk about a little more as we go on.
That's well said.
So one other pivot a little bit here to talk about a bit of a different issue which we raised a little earlier, which is successor liability. So one of the things to keep in mind is in the Goodyear tire case, folks remember from last year, is a really good example of this and how Goodyear had acquired subs in Kenya and Angola, and individuals on behalf of both those subs were engaging in bribery activity in the local jurisdictions, and ultimately the parent company was held responsible and paid a fine as a result of that activity, which did bridge and continue post-merger and acquisition, but nonetheless there was at the time a lack of sound due diligence that was applied when the transactions occurred, and then the activities both before and after the merger. So good points just to bear in mind here is that companies are liable or may be liable for the acts of the subsidiaries and the agents, including acts prior to succession, merger, and acquisition. And as we were discussing throughout this, the third parties, as what happened here, is perhaps posed the greatest FCPA risk to companies, and more than, I think it was both in several reports recently and also in my experience, it's more than 3/4 of all FCPA cases are the result of third parties, broadly defined. So in the theme here, which we'll start discussing in a minute, is that comprehensive and thorough due diligence are essential. They're not a panacea. I think it's important to emphasize that even the best due diligence isn't a complete guarantee, and there things will happen despite even the best intentions. And to bear in mind that in this case is a very good one. Another example where the parent is held liable for the acts of the sub by the SEC. And in this case, although we don't have a lot of time to talk about it, but a great topic is how fines and penalties can be significantly mitigated based on disclosures and cooperation. Perhaps a subject for another day. But ultimately, the company was required to disgorge the profits and revenue that was received from the transactions, and then resolve the matter. So now talk a little bit now, Richard, about can the third-party risks be addressed, and can they be mitigated? And so the next topic we'll discuss and address now is the screening and the due diligence process and the effort to protect the company. So in this particular slide, we're talking about some areas or possibilities that are types of due diligence activities that can be performed. And let's first talk a little bit about what is the purpose of due diligence. Well, the purpose is not really to predict which third party is going to engage in bribery, but it's a process that's designed to help screen potential third parties for corruption risks and hopefully address those risks before they become actual problems. So due diligence should really be designed to screen and screen out potential third parties who pose unacceptable risks, and also to create a record of the screening. I think another important point to emphasize throughout this is that good documentation of your efforts will prove to be quite valuable going forward if, in fact, there's ever an inquiry or investigation and you're being examined for the efforts you made to address your FCPA and third-party risks, which is certainly something that is happening very much so at the moment. So due diligence is critical, and it's what you can do about the risk. So some of the things to contemplate in this area are questionnaires, well-designed and tailored questionnaires to the third parties, the background inquiries done by competent people who know the geography, an examination of the relationships we were talking about earlier. That is, what relationships does that third party have? In some cases where you have some red flags, deeper investigations may be warranted in the screening process. Okay, so when talking about red flags, Richard, so in your experience, it's a very poignant slide. It's only a red flag if you disclose it. And so what do you mean by that?
Well, let's talk a little bit about the environment, Bob, much of which I think you experienced, especially at the Global Fund, where let's look at some of these high-risk, low-integrity regions, which are characterized by weak state institutions, which I define as procurement personnel are inadequately trained and usually poorly compensated, and the procurement guidelines and regulations are deliberately confusing. So in those regions, your business teams are very likely going to rely on their third parties to, quote unquote, sort things out and move things along. And those are the red flags that come up, and I'll pause for a minute here. These are the red flags that happen after the sale, Bob. So it's one thing to behave and engage in corruption to win a contract, what we might think of as grander corruption and bribery, but there's also bribing not to lose, where a contract has actually been signed, and now comes a cascade of signatures, stamps, and inspections that are required for a company to get paid. So all along the way, your business teams are now facing a situation where a particular business, a sales opportunity is in the forecast, there's expectations to get it shipped, to get it signed off on, to get paid, and someone might think about engaging in a corrupt transaction with their third party to move things along so that they don't lose that sale, it stays in their quota, their bonus is indexed to it. And what might make it even more difficult to detect is often in these situations we're dealing with what we might think of small bribery and petty bribery. And, this type of bribery is almost baked into the economic order, Bob, in terms of how these confusing procurement regulations are sorted out by the third party, where they engage in small bribes to get documents signed, stamped, inspected, and you might have a situation where a company employee on the front lines, he might or she might pay that bribe out of their own pocket, or maybe split it with a third party, as thinking this small bribe then gets my goods cleared from customs, it gets them inspected even if they're never even inspected, it just gets the signature that I need, and I get a much larger bonus compared to the small amount of cash I have to shell out to get this thing finished. So those are very difficult red flags to find, and again, they're the ones that people at the front line might think, this is only a problem if I make it a problem.
Well, you raise a number of great points. A couple of things worth expanding on a little bit. One is how bribery is not just a upfront commission to get a contract. It can emerge and present in many different ways and circumstances, including, I think you're describing some types of facilitation payments, but also further payments along the line, which can be problematic under any number of laws, but certainly significant and additional acts of unlawful behavior that could trigger a liability for a company that's engaged or has their representative or third party engaging in those activities on behalf of getting that contract through. So it's a continuing process, in one in which needs continuous and continuing emphasis, that it's not just an examination of the process at the beginning and like perhaps the beginning of the procurement process, but it's the process all the way through. And as we talked about before, and as you know, Richard, a lot of times bribery is made up for on the back end. So perhaps you might underbid for a contract, but you're going to make up for it with contract amendments. I mean, you've seen that numerous times. I've seen it numerous times where there's a contract and then it gets amended several times thereafter, and the companies are recouping and then adding to their profit margin through the amendments, which to offset perhaps low bidding the contract at the earlier stage. Also, the concept of gratuities, that is, bribes, and this is, I think, more than half the time, are actually an after-the-fact gratuity payments that don't occur until the contract's actually awarded and it's actually been signed, sealed, and delivered. And so it's very important that this area and the scrutiny be placed on the after-the-fact payments as well.
That's a great point. If there was a note to self moment in this webinar, it would be, don't let your guard down as thinking the risk ends when the contract is signed, because in some countries where, I mean, literally I consider that bribery is baked into the procurement order, your risks might actually go up after the contract is signed. And I'm always reticent to quote enforcement actions to make sure I've got the right one, because there have been so many, but I think it was ADM that was their particular charging, or DPA, was about trying to get their VAT money back. So I can't think of a more iconic enforcement as just trying to get your VAT back. That's the end of the deal, not the beginning of it.
Right. That's a great point. So let's pivot a little bit to a couple of different or related subjects, but along the same lines, and way bribery is often hidden, and it also involves the language of bribery. And as you know, and we've discussed, bribes aren't talked about as quote-unquote bribes. There's always other sometimes very colorful language to describe it when it's happening and on the ground. And this particular transcript is from an actual case, an actual trial, a matter that I investigated, which resulted in a trial and the plea and cooperation of a procurement official who pled guilty to bribery and corruption and racketeering, and then cooperated in other cases. And this is a trial transcript of his testimony, where he's being examined by the prosecutor. And he's asked, did you speak with anyone in your department about what you were doing? And his answer was, no, I did not. Well, why not? Because the services which I provided the companies were outside of my direct responsibilities and therefore were illegal. And the question was, what services were those? And providing inside information about other companies' bids, including pricing and quantity. And then how were you paid for your services? Well, I was paid into shell companies I created offshore by wire and through third parties. And then the question was, were they called bribes? No, in this case they were called commissions, and the information surrounding the word commission on the wire transfer record was redacted to delete the word commission. So very poignant and I think relevant transcript of how what actually happened in a particular case over a course of time by a insider that was ultimately convicted of unlawful bribery. So now, Richard, to your slide of dealing with corrupt third parties, a ring of lies. Well, what does this chart present?
Well, this is the antithesis to the protect the company chart that you put up. Right? So this is what's going on where people are trying to get around that. And, you know, I'll just do sort of a spin around the wheel here. And I think this is the first one, and it's in red, is not covered by U.S. law. So I don't want to understate this, that for many of these third parties, they do not consider themselves as signatories or covered by international anti-bribery conventions, whether it's the FCPA or the Bribery Act. Their attitude is, it's not my law, or worse, it's legal here. And there was one episode in South America, and I'm not picking on South America today, I promise, where and I testified about this, where a commission came in that was 100% of the sale. So it was equal to the sale amount. So we've well crossed all red flag, you know, boundaries there. And the agent was told, hey, if you want your commission, you're going to have to sign an FCPA affidavit. No signature, no wire. And his attitude was, this is back in fax days, he said, fax me over the paperwork, because guess what? The FCPA doesn't cover me, so I'll sign whatever you want or say whatever you want because I need to get this commission. So, and that was in the context of him sharing it was a corrupt transaction. So I just think we should be careful about the paperwork that you might send to third parties as thinking that their signatures on, you know, anti-bribery FCPA paperwork is somehow or another automatically representative that they're going to comply with the law. I'm sure most do, but I don't think it's an automatic representation. The next one that's in red is about being too close to the business sponsor, the internal sponsor, otherwise known as the employee. What was I doing in Tierra del Fuego on holiday with my agent? You know, in many cultures, especially where business teams are traveling overseas, it's not unusual to spend social time with your agents, to meet the families. You know, in a lot of cultures, to say no to that might be offensive. But to start going beyond that, I think the conversations can open up, people start to get comfortable, and the talk might turn to corruption. So I think as we look at identifying red flags, look at expense reports, but not necessarily for the obvious, but for proportionality. Is this person spending a lot of time with this particular agent, but yet the business doesn't seem to indicate it? They seem to be spending a lot of time together relative to the activity and the transactions. That could be a warning sign. Spending weekends, going on holidays, excessive time together, I don't think is necessarily a good thing, where for a lot of people on the front lines, the more time you spend with your agent, the better. It means you're getting closer. They're not going to go to a competitor. So I think there's some inherent tension there that needs to be addressed. Corrupt local data, and Bob, I'll share my experience, and I'd like to hear yours. You know, in the world of automation where companies are able to get information from perhaps local and national registries about third parties, can you really count on that data? Does it really tell you who's owning these companies? When I was working in the Middle East, I was directed to work with certain third parties because they were family owned within that particular ministry, and was told, if you don't deal with that third party, you're not going to do business here. And as far as best practices go, you know, and Bob and I have talked about this, the State Department and the regional security officer, the political and military affairs advisor, is a wonderful source of local information. They very much or often know who's clean and who's dirty in a company, and it's a resource that's local, that is probably in some of these cases, in some of these regions, more reliable than what you might see in a national registry. Bob, what's been your experience with that?
I think absolutely the same, Richard. It's a great point, and it's one, you know, worth really emphasizing. So, as I said before, every region is different, so anyone who professes to be knowledgeable about every region, or can be someone who can do due diligence all over the globe, I would look very askew at that. I think every region is so different, and I've found so many times that the local data is completely wrong. It's absolutely and often useless, and you can't count on it, just like you experienced, Richard. And I fully agree that, in my experience, I think every time I went to a country, you know, I checked in with the State Department, who had incredible intelligence. It was often right on the money. But it underscores the point of really associating with or engaging somebody who has deep knowledge with the local geography. It's so important. And the other great point you raise with the expense reports, you know, and this is a theme I think throughout this, is that a lot of this is common sense. You know, problems typically will emerge and arise. You know, red flag will be, you know, just commonsensically something's wrong here. And you know, it's interesting. Your story about your vignette about expense reports reminds me of a case just about a year ago when I was in Cambodia, and we were doing an internal investigation of a very large Japanese company that had gained some huge contracts in the Southeast Asia region. And talking and questioning the administrative officer who approved invoices at the first level, and when asked whether she knew that there was something wrong with that invoice from the third party, when she looked at it, you know, she bowed her head and nodded. You know, so, you know, these things, it's not rocket science. I mean, these things emerge. The red flags do emerge, and, you know, applying common sense to a lot of these, especially the invoices and expense reports, goes a long way in and of itself.
Well, thank you. The impact of regime change, I think, is an interesting one. And I know we're starting to get a little short of time here, and I want to remind everyone that we, you know, would enjoy your questions. So feel free to submit those now, and we'll get to as many as possible at the conclusion of our presentation. But talking about regime change, there was an agent, again, South America, where no indication of corruption, Bob, and I called him up and said, hey, you know, what's going on here? And he said, look, the regime has just changed hands. The new people are being seated at the ministry level, and once the turnover occurs, and this was on a recorded line, he said, Richard, when the new procurement people get seated, they know that they only have a few years to make their pension. And those are my buddies, and we're going to start doing business. So there's a case where someone went from being what might be considered to be on the legitimate side of the business continuum, and due to regime change, they ended up on the corrupt side. And I think you had an example as well, Bob.
Right. Well, it's a great point, Richard. I think it shows how things can change in an instant in the local region. And for example, we were in Niger about 2 years ago, and the regimes changed, and all of a sudden the new president was more than happy to support investigations of the previous president and basically threw all the prior officials under the bus and exposed all their activities. But everything that previous government had done was no longer of any use to anybody coming in now, because the government was completely new, and the ties were altered completely and substantially. So there was what you had before was no longer valid. So it's a great point, and something you need to be very timely with your information and your data.
It reminds me of I think it was a Kroll report that said, "Don't vet and forget." So I think those are two good examples. So finally, on the self-assessment part of this wheel, and I read a lot about self-assessments as part of the due diligence process, I'll just share an anecdote about while I was cooperating with law enforcement, I had distributors who were sending me, and agents that were sending me their self-assessment to an email address monitored by federal law enforcement, asking me to complete their self-assessment paperwork for them. So I think that while I'm sure in some areas it's an appropriate form of due diligence, I'd be very careful about the self-assessment process. So that's a little bit on the wheel, Bob. Thanks for the time.
Sure. And Richard, a really good question has just come in on franchisers. With franchising agreements or master franchising agreements, and the question is whether in the international franchisee to developer context, does the developer or franchisor have equal or greater, where they have equal or greater financial means and likely extensive local relationships that will benefit the franchisor in that foreign market? Is the franchisor responsible under a successor liability or some other theory? I think it's a great question, one that's actually very at the forefront. I think I just remember reading a advisory opinion that came out of the government on this question, and I think the government's view is yes, franchisees can bind the franchisor, and that is considered an agency-type relationship sufficient to pierce to hold the franchisor liable. So in that context, there's definitely ways to protect or limit the risk for franchisors for perhaps the acts of the franchisee, the local franchisee on the ground. And there are ways to do that, and I think we're going to come up on a couple of those towards the end of the presentation on the documentation portion of the presentation. So hopefully we'll get to that.
Thank you.
So just as you said, we're starting to get a little short on time, so I'm going to move forward a little bit more quickly over the next couple. So this is just a theme that touches upon what we're talking about, which is common sense. And this is an actual picture of a contract for food rations for a particular developing country which didn't have a shortage, but this is the warehouse of the food supplies that are going to the region. And it was a clearly manufactured contract simply to get it through so the contract was executed. And again, it's along the lines of ask yourself, does the contract make sense?
Absolutely, Bob. And I mean, I had a small Caribbean island order enough defense equipment to last forever, if we could define it that way, and it was equipment that they didn't need. And I also knew that it was an outgoing president. So I didn't have to call up the third party there. I understood that this outgoing president was using defense purchasing to facilitate corruption, you know, call it a corrupt golden parachute. But I think that puts companies in a really interesting position, because if it looks too good to be true, there might be some issue with that particular purchase. So if it's buying large quantities without asking for a discount at high prices, you know, as that picture demonstrated, buying in quantities that don't make sense for the market, you know, you have a choice. Do you enjoy the business, or do you start asking the questions as to why this transaction is occurring in that particular case, as it doesn't, there's no logic to it. So these are great examples.
Okay, and now let's move a little bit, transition a little bit to the next topic, which is the money flow. So an area which is critical. We can't do the topic full justice with the time we have, but certainly a very important one, and that is the flow of the funds, the payment of the contract amounts, as well as the commission or bribe payments, and the way those are facilitated and moved are critical, and also can present real insight into how these schemes work, and then correspondingly how to mitigate them. So Richard, in your experience, what can you say, and can you tell the audience about what you've learned about how this process works?
Well, I think I'll go back to the be careful about complacency after a contract is placed. And I would almost recommend looking at events after a contract as a default red flag. In other words, scope of work maintenance agreements, retainers for contract maintenance, marketing allowances, and the big one is post-contract amendments. I mean, why would a contract need to be negotiated? Why would a price need to be lowered after the agreement is signed? These are all ways that I've seen and I've participated in where the funds are taken out of the company after the contract, when maybe the focus on the corrupt elements and the red flags is lowered a little bit. So I'm particularly cautious about things that occur after a contract is signed. I think you need to watch your risk there. And I think you also should look very carefully about where you're not indexing risk. So looking at my own plea agreement, I was charged for illegal conduct that occurred in New York and in Holland, for example. Those probably are not on the top of your risk screen. So I would discourage complacency in areas that you might think of as low risk. And Bob, as you know, in the UN contract, the commission rate was 5%. So also don't just focus on the commission element as being the indicator of potential corruption. So those are a few sort of broad categories about things to look for in how the money gets from the company to the agent.
Right, and this next slide kind of typifies and expands on the point you're making, the points you're making here, Richard, which are great ones. You know, this isn't, it can be, sometimes is, but often is not straightforward. And this is a diagram of an actual case of not only bribe pay and commission payments being circulated to get from the company to the ultimate third party and the beneficiaries, but also depicts how the third party, as well as the insider, created nominees and shell companies and moved funds offshore through those entities. And this can be something that's very difficult to detect, especially if you don't have subpoena power and the ability to get at bank records. But often funds are moved indirectly through other nominees or shells, and this particular one was discovered actually through an email, and the name was sloppily included by someone who actually was very careful. But the one email where they referenced the nominee company was enough to uncover this, and so it shows how complicated it actually it can get.
So, Bob, now that we've talked about what the challenges are, what do you think are some of the ways to audit, to monitor, and to sort of structure the enterprise to minimize that risk?
Right. Well, obviously this is a critical subject, critical area. Well, there definitely, again, as I said at the outset, I mean, 100% success just can't be guaranteed. I mean, you can, I think, do the best you can do. And there are some ways in which you can certainly limit your risk and your liability. And I think in this slide it presents 3 areas that can help do that. One is just the document process. We talked about making sure that the documents, the contracts with the third parties are very tight, that they have good language to require the third parties to comply with all FCPA rules and regulations. And also, it's a good point, something to bear in mind, is you need to make sure you push this down and require the agents to monitor their agents and impose the same kinds of restrictions and obligations upon them that you're imposing on the direct third parties. Because remember, a lot of times they're going to be sub, and even further agents and intermediaries. It's important to make sure that those entities are also bound to act appropriately, and so you're not caught out being liable for them. So a couple other things we can talk about. Audit rights, huge. The ability to go in and audit the third party randomly and have access to books and records is termination. It's critical you have the termination clause in your documents allowing you to terminate a contract with a third party who engages in proper conduct. Similarly with protection, the protection rights we talked about. And then outside counsel can also be a huge help in the sense that it can provide you cover with, but you have to make sure that the language is right, that their letter has the good language, that it's examined the circumstances of the transactions or the relationships and does not identify FCPA or corruption risk. Then monitoring.
Again, just one question, because you read a lot about this. In terms of the sort of organizational reporting roles in due diligence, any sort of best practices that you might share?
On outside counsel?
On outside counsel and the relationships within the organization.
Right. Well, I know there's a lot of debate now on whether compliance should report right up to the CEO or they should report into the internal legal unit, and who should report or engage with the outside counsel. I think that's a topic for a lengthy discussion. I don't think there's any one right way to do it, but I think that certainly a well-informed internal legal unit should be involved in the process that engages with the outside counsel and also with the compliance department, because they understand the risks and the ramifications of what compliance is finding. Again, can provide sound advice and confirmation that what is being found is a problem or not, and can give good advice to the more senior officials who have to handle and deal with what's being found by the compliance folks. So that's my own view of it.
Okay, thank you. I appreciate that.
And then in just getting to the monitoring piece, again, as you so aptly say here, don't vet and forget. So you vetted the third party, it looks okay, you give it the green light. It's critical because that monitoring occur, testing, auditing, and also be careful of triggering events, big contracts or even invoices and payments. Do a random monitor of a transaction and just do a deep dive and a deep drill, not to every contract, but perhaps select a significant one every 3 to 6 months and do a deep testing of it. If there's problems that are emerging, they're not going to be sole or individual and sole instances. It's going to happen, more than once. So, a monitoring program that can really pick a lot of things up. What's your experience with this in this area, Richard?
I have focused on the don't vet and forget in terms of my experience, how it's just not a static situation, Bob, that I've seen just many examples of how agents evolve and, through the course of their sales experience and representation experience can really change positions on that continuum of corruption. So I appreciate you, sort of focusing attention on it. I think it's extremely important from an auditing and, as you said, a testing perspective.
And then, another good point which you raised earlier that's relevant here is, the use of databases and, computer software. I think we're both take a similar view of this, and a lot of times I think often some rely on the use of software to identify risks. What's your view of that?
I think there's danger in over automation. There's, I think, an important narrative here and a human element to try to gather this information that automation might not automatically detect.
Okay. Actually, there's a great question that just came in, Richard, I think is worth addressing. And the question is, if you hire a company that agrees to comply with your company's FCPA policies, is that enough? Or do you need to make sure they actually have copies of your policies and review them? Do you want to take a first shot at that?
Well, the civilian perspective on that is, as I shared, it's not necessarily representative that the third party embraces the law. It could just be that philosophy of it's not my law, so I'm happy to sign this.
Yeah, no, I fully agree. It's definitely not enough. I think it does provide some protection. You get them to you agree to comply, but there could just be words. It's important that, what's going to happen is the government is going to look and see, how diligent and how consistent is your process and your oversight and due diligence. And if it's just sign and forget, it's pretty clear that's going to lead to a ding. I think it's a negative. But if you monitor, you ensure that the company does training, you actually do some spot auditing or spot monitoring. If you actually do some training yourself or become a little more proactive, I think that gives you a lot more protection than simply relying on an attestation that the company is going to comply. Mm-hmm. I think by being a little more proactive, you're going to do wonders to protect yourself if, in fact, something does go wrong, because this is clearly an area where the government is going to say, well, how diligent and how active are you in monitoring and engaging with your program and making sure that the third parties are complying. So, okay, so moving on, bribery beyond the FCPA. I think it's a critical point to keep in mind is that foreign bribery or bribery is much more than just the FCPA, that there are many different laws that can apply to the bribery activity, and not just in the official foreign official context, but even in the private context. And I think the FIFA case recently is a great example of that, where the RICO and mail and wire fraud laws and statutes were used to address a large or a more global bribery scheme, and to think that you might beat one of the FCPA elements shouldn't give a lot of satisfaction, because there's a number of other statutes that can be applied and have been applied, racketeering, the wire and mail fraud statute, money laundering, like the movement of money that can easily trigger as we talked about earlier, some of those transactions could easily trigger a money laundering charge. The Travel Act is another statute. So it's important to keep in mind that the conspiracy and aiding and abetting laws can reach the foreign officials and others that assist with a scheme. So there's a number of different laws that can be applied, but I think the big thing about the FCPA is it has that books and records provision, which requires you to accurately memorialize and describe all your financial transactions. So that's one that's actually used more than the actual bribery statute. So that's very important to keep in mind when thinking about laws that apply. And then the other thing is now local laws and the effect of a resolution under a U.S. statute, or there's a U.S. plea. Now you need to think about perhaps some ramifications in other jurisdictions that would have venue. So that's another thing now to keep in mind as other countries become more active.
And as someone who is nearly double charged in the United Kingdom, I totally agree with that perspective.
Thank you. I think we're quickly running out of time here. So just quickly, I want to talk a little bit about the case I mentioned earlier today, which is the BHP Billiton case, where I think puts compliance potentially in a whole new light, critical light, and that is this case where the SEC fined the company $25 million for simply compliance failures under the books and records provision of the FCPA, where there was actually no illegal contract. There was no quid pro quo. There was nothing flowing from the entertainment that was provided. The company was held liable for perceived failures, the SEC's perceived failures of the company's compliance program, that it wasn't, in their view, vigorous or robust enough to address the risks of corruption, even where no risk actually materialized. So it's a very significant case, I think one in which all companies need to really be aware of, be careful of, because here there's no improper government action, there's no quid pro quo corrupt intent. The internal controls of the company in the SEC's view were not sufficient. So something to really keep in mind when examining your own compliance program. And here, the deficiencies or alleged deficiencies really weren't, that, I think, significant. There were actually efforts to address corruption risk, but there were gaps in the efforts, and some forms weren't completed. There was a failure to undertake specialized training on certain risks. They didn't have legal review of their these applications, so there was hospitality applications that business officers had to fill out for taking foreign officials to the China Olympics, and so those forms were actually created to address the risks, but they were found to be a deficient process. So it was only the extensive cooperation and remediation, according to the SEC, which mitigated the ultimate penalty. So something to bear in mind when talking compliance. So I think that's our presentation on the third-party risk and due diligence, and I think we're at the point where we're happy to take questions, if there are any more.
Yeah, it looks like the questions that have been presented you have answered, and you've still got a few minutes left. So if you'd like to, leave people with any takeaways, or if you want to amplify anything, now would be the time to do that.
Richard, want to wrap up?
I think that sort of going back to the focus on the bribing not to lose, I would encourage organizations to start looking at compensation plans, particularly how they're indexed. So for today's attendees that are operating in public company environments, I understand the necessity of quarterly forecasting, quarterly quotas, and usually bonuses are indexed to those. And where that's happening in high risk and low integrity regions, you might have a sort of built-in contradiction between anti-bribery compliance and sales success, bonus success, where, in that kind of environment, compliance can be thought of as bonus prevention, where someone's looking at making a quarter, making a forecast, and it's just going to take a small bribe, to get something off of an inspection dock and get that sale within the quarter that it's forecasted. And there's a great trio of articles in the Harvard Business Review about compensation, and it talks about how in regions where they're marked by sales instability, which I think I've described as where the institutions of state are weak, that you really should look at the horizon of which you're compensating people and how it's indexed in terms of frequency. And if the message that you're delivering is we don't care what that means for your quarter, if it means paying a small bribe or a big bribe, we just say no, and we don't care if we have to push that sale into the next quarter or the quarter after that. We don't get held up and pay for business. So, this whole idea of incentivizing and indexing when it comes to quarterly performance, I think presents great risk where people are working on the front lines in these low integrity regions where we have procurement regulations that are confusing and potentially, baking small bribes into the procurement order. So that would be, one of my takeaways from today is to start to take a look at compensation and bonus plans in the context of those regions.
It's a great point. I think I would certainly echo that. And just like my own view, and just to maybe pivot a little bit, I think, this issue, this, third-party risk and this due diligence topic, I think is so important and so critical. I think, as we said, third parties pose such an enormous risk, and especially when you're being represented in a local jurisdiction. Having spent quite a lot of time in a number of jurisdictions or developing countries, it became quite clear to me that in some places it's impossible to get a contract without using the local agent and without paying either a commission or a gratuity. There's such pressure to make the payment, because there's also a view, and I think there's also a theme, that if you don't do it, someone else will. And I think that is actually very accurate. And so there's a real, I think, many companies have a real decision to make when seeking to venture into some of these very high-risk environments, whether it's what's the strategy. I think it needs to be really thought through, because the risks are really so high in some of these locations that it's very difficult to get around the local reality. And you really need to think about how you're going to address it. And I think there's still a lot of activity which goes unaddressed. But now with the whistleblower programs by the government and the avenues for many avenues for reporting suspicious activity, a lot of this is a real risk not to bring this to the fore, because and to think that it may not see the light of day. I think where in the past that was much more. I think the reality or possibility. I think it's much less so now, and so the likelihood of actually having these kinds of activities be identified is much greater today. And so it's something that really that needs careful thought in advance to address. the risks in some of these locations. So very difficult, but you know, a lot of the strategies I think now can certainly help.
That's a great point, Bob. And as you have seen as a global practitioner, that in some of these regions, without sort of a long-term view of developing the business, I think companies have to take a look in the context of third-party risk. Is that a region where sort of short-term return on cash invested while behaving ethically, is that even possible? And I've been reading about, you know, some multinationals that are pulling out of regions just because they don't see how it's possible to succeed there in the scope of what you just said, that if somebody's not doing it, there are two people that want to do it. And there's no shortage of third parties that are there to facilitate those transactions.
Exactly.
Okay, I think that brings us to the end, unless you had any final comments, gentlemen. I think we're good.
Great.
Okay.
Well,
all right. So
thank you very much.
Yeah, you bet. Well, once again, you've been listening to this LexisNexis webinar, a holistic approach to due diligence and third-party risk management. You've been listening to Robert Appleton with Dave Pitney and Richard Bistrong. And let's see. I want to thank Bob and Richard. Thank you guys so much for this outstanding program. You obviously draw on a wealth of experience, and it showed in your remarks. So for our attendees, thank you for attending. Please take a moment to complete the survey. It's going to give us excellent feedback so we can continue to create these webinars throughout the year. Once again, I'm Tom Hagee. Thanks, everyone. And with that, the webinar is adjourned.